From Deputy Wilson.
Thank you. I'm Ian Gorst, Minister for External Relations.
Elaine Miller, Assistant Minister for External Relations.
Helen Delacour, Director of Financial and Professional Services.
Tom Lefevre, Director of External Relations.
Cora O'Brien, Deputy Controller of Revenue.
Kate Nutt, Chief Officer External Relations.
Dan Marcus, Head of International Compliance.
Thank you. Thank you all. Minister, before we get into some of maybe the more technical questions, could I just ask you, perhaps this is, I think, the last quarterly hearing of our term, could you give us an overview, first of all, of the things that you're pleased that you've achieved as a team together in this term, and then I'll ask you about anything that you think is either not has fallen off the table, so to speak, or that you still think will need further work.
I'm pleased to do that. We've done a lot of work on the external relations side in building and strengthening our relationships in Brussels and in London, particularly in regard to seeking to work to overcome the friction that Brexit delivered with the reset, and we've got good relations, I think, on all fronts there. Of course, that reset's not yet fully negotiated. There's a heads of terms, as it were, but we are included there, and we're in working with them on that, which can only be a positive thing, and that will continue to work throughout the course of this year. We, of course, one of the good things that we've done over the last 2 years is managed to sign a DTA with Bahrain, but you've asked me some questions about that in writing. And we've also strengthened our relationship, I think, in the USA, where we know that that's an important market on a number of fronts. During the course of these 2 years as well, we've engaged extensively with US firms around our Pillar 2 offering, and that's been incredibly well received, even though we know that the side-by-side arrangements have changed that landscape. The work that we did around that was incredibly well received, and I think it's something that Jersey can be proud of. We've done a lot of work trying to understand the changing global financial services landscape and what that means for Jersey with all of our competitiveness work. That will hopefully be brought to a conclusion from the report side before the election. But what that will mean is that there's a lot of work for the incoming government to do to respond to those global changes in regard to competitiveness.
Can I ask, so some of those areas we will go into more detail with our question plans. We do appreciate the overview. Can I ask specifically about the reset of the relationship with the Eurozone and Europe more generally post-Brexit? When you say the reset, is that, are we trying to reset Jersey's relationship specifically and if with the EU? And to what extent is that tied with the UK's approach to their relationship?
Well, I think generally speaking, when we think about the word reset or use of the word reset, we're directly thinking about the reset of the relationship between the United Kingdom and its dependent territories. So that's the main thing. But the reality is that we've also really, I think, had a positive reset in our direct relationship with Brussels and commissioners and the Commission per se. So I think it's twofold, really.
Okay, thank you. Anything else to add from your Assistant Minister?
No, I don't think so. That's a very good summary of what's happened.
And I suppose the last part of the question was really to do with, have there been any frustrations, I don't mean general, just specifically in your department in terms of what you've maybe not been able to get over the line, what you think needs more work in the future?
I think it's a good question, and the only area where I could think I wish it would have been nice to make more progress, but it's not directly within our gift, is being included for services in the UK's free trade agreement arrangement. and we are making progress there. The UK now, I think, has a really good grasp of why that is positive, not only for us, but for them from a foreign direct investment perspective. Also, any new government, as we saw in the new UK, doesn't always want to take the decisions of the previous government. They want to do their own work again and have a look at it again. And I'm pleased that that now has concluded as well, and they see no reason why we shouldn't be included for services, and therefore they're more empowered to make that case. So we're not yet there. We might be there before the election, but it's difficult to. The UK's had its own political difficulties, and therefore is not necessarily focusing on some of these big areas. So that is an area where we're still making progress, but we're not quite there.
I was going to say the other thing we probably should just remember is the Moneyval report and just how very strong that was.
Yeah.
Which of course has led to more work, but I think that was undeniably a very good result for Jersey in the financial services. You know, we should remember that as a success of this time.
Okay. And alignment is appropriate versus when Jersey should be maintaining a divergent approach.
Well, as we know, sanctions are a foreign policy tool. UK is, as a matter of international law, responsible for our foreign relations, and therefore when it comes to sanctions, it's absolutely appropriate that we align with the United Kingdom, and these amendments mean that we continue to do that, and they are largely amendments, which means that we will continue to align with them. It would not be appropriate for Jersey to be a backdoor for any sort of UK sanctions evasion. As you know, we in our law we follow UK sanctions and UN sanctions, but this has been particularly important in light of the Russian invasion of Ukraine and the war there.
So there's a Regulation 3 in these, what's been proposed here, and essentially, if I understand it correctly, Regulation 3 is to broaden the reporting requirement for designated persons. So just so we know for the listening public, I suppose, could you just remind us what a designated person is under this law?
Well, I suppose it's as described. They're designated, which means they're subject of a sanction. And what this law really does three things. So it clarifies the meaning of making available indirectly to or for the benefit of a designated person. That's somebody who's subject to sanction. To make it clear beyond any doubt that funds or economic resources are not to be made available to any entities owned, held or controlled by that designated person, as well as to the designated person themselves.
So this puts a further requirement on which doesn't currently exist in Jersey, that if it's not a direct client of yours or somebody that's within the direct orbit of your business dealings, that you're still required to report that. Is that correct?
Yeah, so that's a slightly. There are largely three amendments, and that's not the one that I've just answered your question to, but it's that's the one about disclosure around the information that you might come across. So currently, it's the disclosure is a direct connection. So if you were operating an account of a designated person, or you suspected that there was a transaction connected with your organisation, you would do that. What this does is just slightly broaden that out and say, you might, in the ordinary course of your business as a financial services company, come across accounts held elsewhere or actions being undertaken elsewhere that you think, oh, that could be a designated person. It's just saying, okay, well, you should report that as well. And that really, I think, is quite an important, even though it's a small amendment, because it does mean that we can have even more confidence than we've already got, and I think we've got a high degree of confidence that we are having reported to us transactions and accounts and things like that in an appropriate way, but it just slightly extends it. We've been out to consultation with with that. The JFSC are aware of it and supportive of it.
How long have you been aware of that? Let's call it a legislative gap in this area?
Well, I'm not sure we could even call it a legislative gap. I think it's just a strengthening of our legislation. And as you mentioned at the top of your questions, it brings us in line with UK and international partners. There's not been anything to stop firms already doing this, and some have been doing it. This just makes it clear that actually it's a good thing for everybody to be thinking in this way.
And during the consultation process, this was generally not seen as having any adverse impact on companies?
I think it was largely neutral. I think there was one consultee that maybe grumbled a bit about it, but there was also one consultee that thought it was an important and good change.
Okay. So one of the questions will be a theme through some of these more general questions is about the idea about how you decide what the balance is between compliance and best practice and meeting whether it's UK or international best practice versus government's more general commitment not to add red tape to various sectors. How do you apply that test?
Well, I think it's a very good question. And I think it's a question and a test that hasn't always been used in the past. To my mind, it's absolutely clear that with something like sanctions, it is appropriate to be following, as you asked me at the start, the UK approach because of the constitutional position and the desire not to be seen to be in any way helping to support Russia's invasion of Ukraine. And therefore, I think it's quite a straightforward test. We're just following the UK approach. The broader question, of course, is where in regulation do we take the international standard? If it's AML, CFT, then we're looking at the FATF standard. And are we going above and beyond what the standard requires? So meeting the standard is absolutely fine. We continue to aspire to doing that. The question that there is a correlation between making sure you're just meeting the standard and not adding any extra red tape or bureaucracy and having an economy that's growing.
Yeah, okay. I presume sometimes it's also anticipating what's coming down the line so you don't have to keep making changes and try and be future ready, right?
Well, that's a good question because if you take the FATF requirements on recommendations, the way that you're being assessed about them is always changing. So you can be, on the one hand, you can be ready. On the other hand, it's going to change anyway, so you have to respond to that between the changes or between the stages of review. So yes, we follow closely, and Helen goes out to Paris or wherever it is to these plenaries. I'm sure they're terribly exciting, but we follow that. We have a head of delegation also in Jersey that goes, and we adjust as we go. But we are mindful at the heart of that adjustment, probably in a way that we maybe haven't been previously because of the changing international agenda around financial services, that we've got to get that balance right.
Thank you. Okay, I'm going to pass over to Deputy Andrews.
Thank you, Chair. No, thank you for being in attendance today, Minister. I'm going to move on to the draft Director Disqualification Sanctions Jersey Amendment, and that's covering the Companies Jersey Law 1991 and the Limited Liability Companies Jersey Law 2018 as well. And I just really wanted to have a broader understanding of why the rationale to bring about these changes has been proposed and how it can take effect and improve things.
In effect, this is just making, if this is one we're talking about, making an amendment to repoint at the order.
Yeah, for the licensing provisions, yes.
Yeah. So it's just correcting something that I suppose, wasn't, in a way, slipped through the net when we made those changes previously.
Okay.
So it's repointing back to it to make sure that it's absolutely clear.
Yeah, yeah. So obviously this is to do with director disqualification sanctions.
Yeah.
And in the report, there is mention under Article 5B of the sanctions and asset freezing implementation of external sanctions, Jersey Order 2021, where that is going to be exempt. So somebody could potentially be disqualified, but under that area, they wouldn't be disqualified.
Well,
I want to understand why that is.
only with the issuance of a licence. So the sanctions regime
Yeah.
operates to, if you come back to, it's a foreign policy tool.
Yeah.
And at its heart is not wanting to provide money that's held in our jurisdictions to support Putin's war in Ukraine. And it's saying, okay, so individual people are designated, funds are frozen,
Yep.
but that's not to say that you can't apply to the government or to Dan's team to request a licence to do various things. Mostly it might be paying lawyers, it could be paying service providers, paying bills if you've had to have repairs done on a house or just general upkeep. So you can get licences. Our concern is that those funds that you get a licence for isn't finding its way to supporting the designated person or, of course, more broadly, the war in Ukraine. So in this case, we're saying no, that those directors should be disqualified.
Yeah.
But there might be a case where a licence would be appropriate to allow an existing director that's being disqualified or been disqualified
Yes.
to be in place to support that particular decision.
Okay.
But it only having come back to government to request a licence to do so.
So under Article 5B, the person would be placed under restrictions compared to, say, the other two laws. Is that what you're trying to say? Because if that's not the case, then it seems a bit ambiguous.
Well, I don't think it is ambiguous. It's saying that directors can be disqualified.
Yeah.
But there might be extraneous circumstances where you that something needs to happen under a licence from government, whereby you'd need to have that disqualified director for a set decision or job just to do that thing until other directors are appointed.
It would be very specific. It would be a very specific set of actions that would be outlined in the licence, and it would be for a temporary period of time as well, just to enable them to do whatever it is they would need to do as a director. After that, they would revert back to being disqualified.
And in terms of when we're looking at oversight, obviously there'd be questions about whether somebody is disqualified, if they're then given a licence, even if it's for a temporary period, what's in place to make sure that...
Yeah, so the team do that.
Yeah.
So nothing can happen outside of the licence, and the licence is very descriptive about what can be done.
And the team keeps track of that
as well.
Yes, and there would also be reporting obligations within the licence under which they have a legal obligation to explain what they've been doing.
Okay.
And it would be, it would be very carefully drafted to ensure that they could just do what we wanted them to be able to do rather than anything broader.
Does this follow a model elsewhere? Is this practice in place elsewhere?
Well, in the UK, they have they introduce this director's qualification sanctions.
Yeah.
It's a model.
But I mean, for the
licences, absolutely. So as the Minister was explaining, for all sanctions prohibitions, there will be licensing provisions that you, under certain circumstances, you can apply for. But you have to, not only they have to comply with the relevant licensing provision, you have to make sure that no licence is going to enable the undermining of the overall policy intent of the...
Was any consideration given to designating somebody else other than the disqualified director to be able to carry out those?
Well, in Jersey, other than for terrorist asset freezing designations, there are no powers to designate in Jersey anyone for sanctions, whether asset freezing or direct disqualification. So specifically for the direct disqualification sanctions, these will just be UK designations. And so, I mean, there are thousands out there. Almost.
Sorry, I was still talking about the license. So when I meant when the decision was taken to allow time-specific licensing for a disqualified director to make certain decisions, limited decisions, was any consideration given to a different method to achieve that? i.e. not give that person the...
But it's not really, because this is the method that the UK have used, and it's a common method across all sanctions.
But it will be monitored, that's the point where...
Yes.
So we're seeking assurance on. Thank you.
As all of this work is quite, how can I put this, it's quite bureaucratic heavy. It's quite technical and difficult, needs a lot of input from in regard to specific technical advice, and a lot of liaison with other authorities, largely in the UK.
And it's actually, it's not a quick process particularly either. So when the licence applications are received by the team, there is a whole, piece of work that goes, that they have to go through to make sure they have all the information they need. Assertions are tested. There is no way of it's not being used to circumvent sanctions.
That's right.
And so how has this been working in terms of, liaising with industry, making sure that everybody is understood so they can then update their own processes internally?
Yeah, I mean, so we've had a version of direct disqualification sanctions in place since about February, April this year, when the UK introduced the sanctions. So in advance of that, there was Gazette notices, there was outreach to some of the industry bodies around the company's law amendments that went through the states in January. There was a process of consultation. There was a working group where we took input from industry about some of the changes around that. So there has been quite extensive consultation and also communication with industry about the changes.
Oh. So in essence, this is really just aligning with international best practice?
Well, with the UK,
yes.
And specifically with these changes, we think the impact will be, quite minimal. I mean, it prohibits people from appointing sanctioned persons, which they won't be doing anyway.
Yeah.
And it allows certain people to apply for a licence. Doesn't mean they'll get one.
Yeah.
But it allows them to at least apply for a licence.
Yeah. Okay. Thank you. Thank you, Chair.
Deputy Andrews, are you happy to carry on with asking about the disqualification? If you finished with the draft director disqualifications?
Yes, I've finished all here. Yeah.
Good. Thank you.
Yeah.
Okay. So, Minister, we're going to move on now to the double taxation agreement with the Kingdom of Bahrain, which you've already mentioned. We've just got a few questions for this hearing. We know we've got a letter sent to you as well for more detail, but I'm going to pass over to Deputy Porre for this.
Thank you. Minister, just to set the scene, we'd like to start by saying that the agreement between Government of Jersey and Bahrain was lodged on the 27th of January. The intent of this proposition is in part to eliminate the double taxation on income for business which operate between the two jurisdictions. What are the specific economic benefits that are expected from signing this agreement for Jersey and possibly for Bahrain?
Yes, well, thank you for the question, and thank you, Chair, too, for the long letter of questions, which is almost ready for signing when I get back to the office later this morning. So DTAs and signing and increasing the number of DTAs has been in the common external relations policy for a number of iterations. And they do, as you said, Deputy, at their heart, eliminate double taxation for business flows between the two parties signing those DTAs. And therefore that's exactly what the benefit will be to Bahrain and to Jersey. We know that there are some Jersey trust and company service providers who've got offices in Bahrain. We know that there's already a good flow of business between the two jurisdictions. What this does is give certainty in regard to withholding taxes for dividends, interest and royalties. And what it will ultimately do is allow for a greater flow of business between the two jurisdictions, as any DTA does. We, of course, in Jersey would like to sign more DTAs. It's probably slightly more challenging for us because of our taxation structure, but Bahrain and other GCC countries are countries that know Jersey well. We've got a good, strong relationship and book of business with them, and this reinforces that.
Thank you. Do you feel that there are any unintended risks that may have been identified with this particular agreement?
In what way are you
Unintended
thinking
risks
of?
within this the signing of this agreement. You have been very clear in specifying that for the purpose of tax is beneficial to Jersey both and Bahrain, mainly when it comes to businesses. Could there be any unintended consequences coming from this agreement?
Not I think that's foreseeable. It's in line with the minimum standards set by the OECD's base erosion and profit shifting, which would have been the risk that one could possibly point to. But being in line with that standard means that I think we avoid that risk.
Where does the difficulty come, or resistance to setting up? That's probably not the right word. The hurdle, shall I say, with setting up any new DTA. I presume you've got a whole list of
It depends
countries you want to do them with.
Well, if you notice the as I read to you there, nil rates withholding tax for dividends, interest, and royalties. So you see there's not corporate tax, and because of the way our corporate tax is structured, sometimes that means that interlocutors are not that keen to do it because they may not see the benefit to their own economy. We, of course, think that there is a very strong argument that says it can still benefit an economy. You pick the taxes that you can agree on, and you facilitate foreign direct investment, which is a benefit to jobs and growth in those economies as well. So, but Tom is the guy that negotiates these agreements on our behalf, using, of course, the base model that we use. So it's quite our agreements are quite vanilla compared to some larger countries.
I mean, if I can move it on from Bahrain, I know we will get the answers back about Bahrain specifically,
yes, you will,
but we come back often to the more general question about DTAs with some countries in Europe that local residents would like to see having DTAs. What are the hurdles for those?
Yeah, happy to answer. Well, I mean, the first hurdle that we have to acknowledge is Jersey is a small jurisdiction and it's sub-sovereign. And there are some jurisdictions that don't sign treaties with sub-sovereign jurisdictions and never done it before. We're starting to see that change. There are more jurisdictions out there that have DTAs, not just with the likes of Jersey, but Hong Kong, other jurisdictions. But for some, that's an initial hurdle, and we just have to acknowledge that.
Yes.
The second one relates to what the Minister said, which is Jersey has about the Bahrain DTA is that it absolutely does provide benefits to individuals as well as to companies. So for our part, Jersey always tries to negotiate full DTAs, which means it's not just about the rates of corporate tax, but it also applies to those the individuals. And the reason why the Minister mentioned the benefit for this one with Bahrain is precisely because we know this isn't just about business flows. We know that there are people, particularly in the finance sector, who move between the two jurisdictions. There are businesses in Jersey that have offices in Bahrain. And so you need a treaty to work out where someone is working across two different jurisdictions, where the taxing rights should sit, so they don't suffer double taxation.
Because this will be the flip side of the coin, which is the next question. How will this proposition prevent tax evasion and avoidance? And to what extent is that a problem?
So again, the really good thing with this DTA is that both sides, Bahrain and Jersey, we tend to use the OECD Model Convention. That has all the provisions in against base erosion and profit shifting, as well as the OECD minimum standards. The treaty fully conforms with those. So we're satisfied and Bahrain's satisfied that we have baked into this treaty the sort of anti-abuse provisions that deal with those kinds of risks.
Minister, we're also the economic panel as well as international affairs, and
Have we finished on the DTA or not?
well, it relates to DTA.
Yes,
but
I just
sorry
wanted-
to,
you go and then
I just wanted to say I should have Neve is sitting quietly behind me.
Oh,
When I said that Tom negotiated these, Tom is the diplomat and Neve is the technocrat. So they do it together with us because she's sitting quietly. I didn't want her to think I'd forgotten her important role in this.
I was going to ask who the brains is behind it, but I think that might, you get into very dangerous territory quickly.
The other point you asked about a wider network, we have started a conversation with Romania about the possibility there of signing a DTA. That's, I think, been well received at the embassy level in London.
Yeah.
But that then needs to go up, and there's more work to be done there. Whilst not a DTA as well, we are engaging with Portugal as well, and we're probably going to be an inbound visit, hopefully before the election, to talk about their tax blacklist, but also the potential there for a DTA. But that I wouldn't want the public to run away and think, oh, we're going to get a DTA. It's
The front page.
Because it's not that at all. It's a very, very slow process. But we try to, with answering your question about where we think there'll be local benefit to residents as well, we do try and engage, talk about those in our conversations as well, because we recognise that there are many benefits that could be gained from them.
That's great, because my next question was going to focus on what other countries have you been looking at signing the DTAs. Romania and Portugal are really positive news. Any others following from these?
Yes, well, there's a few others as well, largely either African or GCC countries.
What considerations do you give when you look at signing these DTAs with new jurisdictions? What are the principles of your considerations given those agreements?
Well, I think firstly, principle is that we want a model agreement based on the OECD model. Makes it easier. It shows that we're meeting international standards. It's more straightforward from negotiation, and it avoids those pitfalls that you've been questioning about earlier. Then there's whether there's twofold things. So we've got the ones which would benefit a great number of residents per se, with the ones we've just talked about, and then the business flows as well. So where are we seeing business flows coming from, and how can we enhance that, or where do we think there are other opportunities for Jersey's finance and professional services industry to grow more business?
Thank you.
I mean, we do have to ask the perennial question about human rights considerations. So Bahrain doesn't necessarily feature very well on certain human rights watch lists. Are those including rights of women? What considerations are given to that specifically when dealing? Is that something that your department is neutral on, or are you aware of the wider implications?
Well, I think firstly, when it comes to the agreements themselves, we're very clear that these are in effect trade agreements, and therefore they focus on that element. In this regard, taxation, or with bilateral investment treaties, it's about investment flows as well as the supporting tax element. As you know, whenever we visit a country, we engage with the in-country embassy or High Commission and meet with the High Commissioner or ambassador. Those conversations, we always talk about the in-country human rights records. And as we build relationships, we follow the UK's foreign policy, but as we build relationships, we find we can have more open conversations. And I think the thing to say broadly about the GCC is that they are on a journey. They have a different culture, they have a different religious base, but they are on a journey to change, as we've seen with the Prince of Wales visit only over the last 2 days. And it's been interesting to see some of the in-country contributors there talking about the change that they have seen. And these things obviously are, that change is something that we support seeing.
And if I can just take this in a slightly different direction, but looking at DTAs from a non-corporate tax, well, not exclusively from corporate tax point of view, but perhaps from an income tax, personal income tax, is there any scope to use DTAs perhaps to allow for flexible working where people are not necessarily based in one jurisdiction or another? They could live somewhere, work somewhere else, and maybe the question of where they pay tax could be decided with reference to a DTA. Is that a possibility?
Well, it's a very good question, because we see some of the difficulties that have been in recent times occurring between places like Luxembourg and France with their double taxation arrangements, and yet people are more mobile and doing more working from home than they ever have. So I think that they can help, but there's also, I'm going to pass to Cora, because there's also things that Cora is thinking about when it comes to mobile working and how we tax them, which is going to be important moving forward. So Cora, I don't know if you want to say a little bit about that as well.
Yeah, of course. So as part of the work that we're doing on competitiveness, we are looking at the taxation of cross-border movements of people in and out of Jersey. And we are looking at ways in which we can reduce barriers that might exist at the minute, or frictions in the system, and uncertainty, where people might be kind of working from a home office here or a base here, but also, you know, potentially employed by somebody elsewhere. A big part of bringing more clarity to that is a review that we are doing on the personal income tax residence regime, which is underway, and we have a goal of having a much clearer, more black and white test for people commencing 1 January 2028. So that will bring a lot more certainty and help to that area of work. And as we do that, we are also mindful that there's more guidance coming internationally from the OECD about cross-border workers and working from home. So I think over the next few years, we will see that change and evolve quite a lot. And then we're also kind of doing, as well as the residence rules, we are sort of doing more to kind of look at how the tax system supports talent and makes it easier to bring talent into Jersey, and makes it easier for Jersey businesses to have people working temporarily abroad to gain experience and bring it back. So it's a big piece of work.
So are we potentially talking about someone that might live in Cheshire or Saint-Malo, but they work in Jersey either remotely or physically, and then the questions about how they pay tax, how they pay social security, what benefits they're entitled to, is that all under consideration?
That's a part of it for sure. Yeah, that's an important part of it. Yeah.
Good. Well, we'll look forward to hearing more about that. And it's not just something for your department. Presumably there'll be some cross-working that needs to go on.
We'll be working very closely with Treasury colleagues on that as
well.
How
far away do you think government is from that being a reality?
Well, the residence regime work is advancing well. We've had a lot of stakeholder discussions, and we will be doing a public consultation on some ideas that we have about it towards the end of the year. So that will be sort of subject to the next government, but we have some concrete ideas about how we should change it, and we will be putting that out for wider discussion, because obviously it affects all industries and all people across the island, and different groups have got different priorities in what they need the system to do. So that is definitely something that you will see within the next sort of 6 to 9 months publicly.
Thank you. All okay on that? Finished with that?
Yeah.
Good.
Okay.
Thank you. We're going to move on to Pillar 2, Minister. You've touched on that already. So Pillar 2 Global Tax work stream. Can you provide an update on any milestones that you're anticipating, hoping for 2026?
I'm just trying to think, Chair, of when the last time I provided you with an update was, as to whether there is an update. Probably there is. You know that the...
well, we can talk specifically about side by side as well.
Yeah, beginning of January, the OECD issued a statement agreeing side-by-side agreement and some other refinements, but it was quite a lengthy document that was issued at that point. In effect, what that agreement is seeking to say is that the US's global tax system can sit side by side as if it were equivalent to the OECD Pillar 2 regime. Of course, we were very careful in our forecasting and the numbers that we put into our budget to make sure that they were a base case. Because we, even though we knew there was agreement, we also knew that there was potential disquiet and desire for change elsewhere. What we are doing now is, for the majority of in-scope companies, they are, all in-scope companies are continuing to register with Cora's team. First payment on accounts for last year's profits are due with the revenue at the end of May. That, of course, will then give us a good handle on what the actual revenue for 25 is. But we remind ourselves that if there is any upside for 25, as we've always suspected, that might be temporary in nature. The side-by-side arrangements we are, of course, also considering, and we continue to engage with both US institutions and non-US institutions. US institutions to understand what their response to the side-by-side change might be, but also other institutions as well.
Is the side-by-side package, is that to be seen as a compromise in keeping countries like the US on board while still...
Well, if we go back to the G7 announcement early last year, or the start of last year, was it? Early, or was it May?
It was May.
It was May, sorry. So May last year, when the G7, as part of their summit, issued a statement saying they'd all agreed that, in effect, the US could be given equivalence. Sorry, what was your question again?
Well, I'm saying that there's obviously been some deal here done.
Oh, yes, was it a
yeah.
deal? So I think what happened there was a political agreement that they needed to accept that there was some equivalence there, because at the time, if you remember, there was a piece of US domestic legislation which was everybody thinks of as 899, which was basically going to add an additional tax for investment into the US. You had also digital taxes, all of that came into the mix. So there was a political agreement back in May, and then the technocrats have had to work through what that might mean in practice. So I think it is what it is. I think from my perspective, it's a political agreement that the OECD has tried to make the best of.
And can you talk to us about any exemptions that have been made for US multinationals and what the concept of safe harbours are in the side-by-side package, if that's relevant to either the functioning of the scheme or for Jersey? Does any of that undermine the...
So it all ends up getting quite technical and complicated, but in effect, some bits of, for us, don't forget, we never had the under-tax profit rule in our legislation, which was the big thing that the US were really upset about because they felt that was extraterritorial. The IIR, so income inclusion rule, that if you recall we had a separate piece of legislation to deal with, the side-by-side means that then doesn't apply to US companies per se. Our MSIT, which was our domestic corporate income tax for in-scope companies, was a bespoke methodology which tried to, in some way, deal with the differential between the two regimes, and it's important now for us to undertake this consultation work that we're doing to understand what the implications might be.
And I suppose the bottom line is, do we know what the anticipated tax receipts will be for Jersey in the next years?
Well, this is why we've taken the cautious approach that we have in the base case and just putting the minimum in that we felt would be payable by in-scope companies that weren't caught up or going to be caught up in these potential changes. So we tried to foresee that right at the start of our budgeting
Just remind us
process.
the figure.
Well, it's about 50 million a year.
No, thank you.
Cora, I don't know if you wanted to add anything else. No, thank you.
That's perfect.
Thank you for that. Okay, I think we'll move on to the next agenda item, which is for Deputy Andrews to ask about financial services.
Yes, so Minister, this is for the financial services disclosure and provision of information. Under the Financial Services Disclosure and Provision of Information Jersey law, there is a code of practice. And I just wanted to know, Minister, whether the Jersey Financial Services Commission has issued guidance about the revised code of practice so people have a fuller understanding across industry.
So are we talking there, are you referring to the consultation that we've just undertaken? Are you referring to the changes that we introduced at the end of 2024 around obliged entities access?
Yes. Yeah.
Obliged entities. I'm pretty sure they have, but I don't have that information in front of me, so I'll just ask Helen.
I'm not sure I have the information exactly. I would imagine so. I think there's a lot of engagement that went on with industry at the time because as we gradually open up access, we want to make sure that people understand the rationale for that and how they can use it. The changes in 2024 only allow access to regulated businesses on island for the purposes of conducting CDD. There's actually been very limited use up until now of that access.
Yeah. And obviously we're living in a ever-evolving world. For instance, with the use of technology, probably the nature of reporting has also changed as well. So do you feel that the code of practice was one that was modern and actually fit for purpose to try and capture some new elements that we've maybe not seen before?
So I think we've just got to be careful with, there are a number, in your question there's a number of questions. So the code of practice that will deal with obliged entities will be fit for purpose as far as I'm aware. I've not had any commentary in the opposite direction. What we have also done in government is issued a consultation document for further widening of access, or something called legitimate interest.
Okay.
And that's a work in progress. So all of that is probably slightly separate from, I think what you're asking about is the use of registers and technology at the registry, and all of that in light of technological changes. And Helen, I don't know if you want to just say something about where the JFSC is in regard to its registry work.
Yeah. So I think, firstly, the codes of practice issued by the JFSC more generally will be considered as part of our wider competitiveness work. So where we are getting feedback that things don't work or there's little niggles, the JFSC is really willing to consider those and see if we can enhance them.
Yeah.
The JFSC is also looking at its registry system for modern updates. They engaged a company last year to do a strategic review. So they've done the findings, and we're expecting probably towards the end of Q1 of this year a feasibility study to have been concluded by the JFSC, so they can consider whether it's perhaps a brand new system, whether it's upgrades, whether it's patches, whatever it might be, to enhance that, to make sure it's the best option for the island.
Yeah. Minister, in terms of your view, obviously it's a very important area in terms of the reporting of information, and do you think Jersey has got that balance at the moment where we are managing to get information reported at the right time, and also that it's a pragmatic approach and it's not burdening the financial industry too much as well?
Well, if we're talking about disclosure and provision of information, then I think the answer to that is absolutely yes, it is. We're going through this consultation. We've made a commitment about legitimate interest. We take a different view from our UK colleagues. I don't think there's a problem with that. Our view is much more aligned with the international standard. It's not driven by politics, it's driven by either legal cases and the reality on the ground. In a tech-enhanced world, we know that confidentiality is even more important than it's ever been. We know that the sovereign case in the EU said that public access was inappropriate and in breach of human rights. And so we are working our way through that process. So I think it's absolutely right, and we've got at the forefront of our minds the continued competitiveness of Jersey. But rightly, if people are coming to Jersey because they see it as a safe harbour, they also expect data security and confidentiality for their data. And that's a challenge for all governments, of course, everywhere, in every bit of government. So I think that's right. If you're asking me a much broader question, which I think you might have been, there are any number of changes that we need to make to get that balance right.
And can I ask, Minister, obviously the Labour government have obviously now taken over in the UK, and I just wanted to know whether you have felt any pressure at all, not from maybe the Labour Party itself, but maybe some sections within the Labour Party who've maybe tried to apply pressure in regard to the disclosure and provision of information that they feel potentially should be more accessible or not.
Well, this is where I make the point that we may disagree with our UK counterparts. We may think that they take a quite a political position, but we refer back to the approach to the international standards and also the approach that Europe takes as well. We've always had a long-standing policy of following international standards. Sometimes we've had to follow regional standards. It's fair to say we have some quite robust conversations with our UK counterparts. We've met with the Security Minister, we've met with the Deputy Prime Minister. I'm meeting again before the election with the APPG on transparency. We meet with no longer Dame Margaret Hodge, but Baroness Hodge. And we continue those conversations. And I think that's important that we continue to engage. During the summer that you had no, it was towards the end of last year, you had a meeting with Guernsey, Isle of Man, UK and the EU about their registries and the World Bank. That was in November. And they came to Jersey there. We're hoping to host another event in the summer with representatives of FATF thinking about the same thing. So we're engaged in it. Just because we disagree on what is the best approach, and we remind ourselves that UK relevant authorities have access to the information on Jersey's register under what's called the
Exchange of notes.
The what?
Exchange of notes.
Exchange of notes, I should remember because I signed it. Exchange of notes in as little as an hour where they think it's necessary.
Okay, thank you, Minister. Thank you, Chair.
Thank you. Minister, I've got some questions for you about the competitiveness programme. I'm mindful that you gave a talk in November, you made a speech in November. Can you remind us what that forum was? It was the Financial Services Annual Update, I think it was. That was the event.
It could have been, yeah, but basically, I think yourselves and industry were all invited to it. Yeah, so we, over the last few years, the Financial Services team have given an annual update about the work that they've been doing to industry. That happened to coincide with that, and we've got then another event on the 16th of March where we'll be talking about the competitiveness work again.
And we may have been invited. I don't think we would have necessarily been free. So, Minister, you said something there which was, I think, quite provocative, but I'm sure you can stand by it. Is that you said it's no longer a privilege?
That wasn't provocative, surely. That's not my style, is it?
He said it's no longer a privilege for financial services business to operate in Jersey. It's now Jersey's privilege to serve them. So can you tell us about what you mean by that, how you think the world has changed?
Well, so the reason for doing the competitiveness work, which has been going on for a number of months now, is largely twofold. The world of financial services is changing dramatically. We can have a bank that's fully on our phone. We never need to go into a building. The way that that bank is regulated is different from the way that the bricks and mortar bank is regulated there. We know, and we're hearing in some quarters about the private borrowing. We see the use of AI, we see the use of cryptocurrencies, whether that's DeFi or it's my age, Chair, tokenized exchanges. It's totally changing. And put on top of that, that competitors that didn't exist. So we've been a successful financial services centre for 60 years. Some of our main competitors didn't exist 20 years ago, and they are throwing lots of money. They are copying what places like Jersey are doing. They are attracting talent. They are attracting business, Middle East and Far East. That the world that we've operated in is totally changed on its head. We have been incredibly successful to date. We've always been a jurisdiction of choice. We've been so successful that we've had to say, well, actually, no, we don't want you. We just want you. So that's totally changed. And so we have got to totally change our approach and recognise that, do we want people to keep choosing Jersey? And if we do, we've got to offer the services, the products, the skills, and the environment that's going to welcome them. On top of that, of course, is all of the geopolitical change that we're seeing, that we can't open our news app in the morning without seeing some
I think the
externality changing.
Thank you. So essentially what you're saying there is that we can't be complacent, I think, is the message about...
More than we can't be complacent, we've got to come up our game. We've got to up our game in government, we've got to up our game in how we implement international standards, we've got to up our game in how we promote ourselves, we've got to stick to our core of tax neutrality, and we've got to get out the message as well that Jersey is the place that it is because we've had a successful financial services centre.
Thank you. So, Minister, with that in mind, you also mentioned something called the competitiveness, the concierge service.
Yeah.
Can you tell us what that is and whether it's up and running yet?
No, so it's not. So we're going through a process of the final report will be with us shortly. We will then produce an action plan.
So what is it, first of all?
Of the actions that's going to be taken.
What is the concierge service? So
a concierge service is basically, well, you don't need me to explain to you a French word.
I need to know what it is in the context of what you're offering.
Well, it's basically reimagining how we welcome new business to Jersey. So, as I said to you,
but how is it different to locate Jersey? Is it something of what they do, or is it specifically?
Well, so I can't tell you exactly what it will look like now, but it's a coordination. Locate Jersey has been doing it in a very, probably quite a narrow field, but I would imagine that we'll take some of that model. Don't forget, JFL are doing, Jersey Finance are doing some of this stuff alongside their promotional work as well. Some of the work that the high net worth team is doing some of this as well. Even Revenue Jersey does some of this because people pick up the phone to Revenue Jersey and say, if I was going to bring this structure, how are you going to tax me? And also at the Financial Services Commission, they do they do the same as well. They pick up the phone and say, oh, we've got this structure. You can see in the current model that it's so disparate, and yet, as I go back to, these competitors that are new to the market, they've got, in a way, one-stop shop where they can control the decisions, and rather than, and this is the other thing is, if you're bringing your business to Jersey currently, you need to get 8 or 9 different yeses from organisations or people or institutions. You can see that if we are competing with a jurisdiction that just has to give one yes because they've coordinated all the work behind the scenes, we're at a disadvantage. So we need to get that provision to the point of, you know, if you want to come to Jersey, you pick up the phone or you WhatsApp or you use the app for this concierge service, and then behind the scenes they're doing all the work to get the decision to you.
Is there a risk here that, so this is specifically targeting financial services, and that's fine because you're the Minister for Financial Services, but is there a concern here that the government more widely is sending out a mixed message that we're open for financial services business, but when it comes to other aspects of the economy or even culturally, we're not open for business? So there isn't a concierge service for teachers or for the hospital or for people wanting to open a sports facility in St. Peter, for example, or a whole host of things. Is this something that could be replicated to say that actually this isn't just for...
Well, I could answer that in many different ways. Firstly, my responsibility is financial services, you know, so I wouldn't presume to answer on behalf of my colleagues. But I could equally say to you that 42% of GVA is provided directly by financial and professional services. When you come to indirect, it's between 55 and 60% of the GVA. It is the driving force of the economy. Other sectors of the economy are complementary, and I am a strong believer in that we shouldn't let them, we shouldn't be complacent with those sectors either, and we shouldn't let those sectors die. So, okay, we're running up to an election, so it's I have to be careful not to tell you what my policies are, because I might see them in a Reform manifesto. But
You'd be lucky.
Well, you might see them in Deputy Andrew's manifesto.
But I think if the heart of your question is, do we need to think about the rest of the economy in the same way? How do we renew it? How do we make sure that it grows and it's got a future? Then my answer to you is yes, we do. But we shouldn't ever forget that this is the driving force of the economy and GVA, and we get the tax take that we do that provides the public services that we do because it's been successful in the past. It has to be successful in the future. If we want to deal with cost of living crises, if we want to deal with investment in our infrastructure, we've got to have the money coming in. This is why it's so fundamentally important.
Thank you, Minister. Make a note of that for our manifesto.
I am already.
Okay, we're going to pass over to Deputy Andrews again for just forthcoming legislation. If you're okay with that.
Yes,
Section 38, question 38.
Yeah. Minister, obviously we've not got long left, and I just wanted to ask you a question about the legislation that you are intending to bring forward, and whether there is any other further proposals that are due to be lodged before the 19th of the month.
I think there is one other which for some reason we're just struggling to get over the line, but I'm hoping it's over the line today. Helen, it's in your...
It's the administration piece. I think that's what you're sort of referring to.
Yes,
isn't it?
that's it.
Yeah. So I think you had a private briefing yesterday around some financial crime elements. We're still going through a consultation process on those to make sure that industry are properly briefed and understand, and we've acknowledged any concerns that they might have. The administration process will is a change under the Companies Law. So I was off island yesterday, but I'm hoping that it was ready to lodge.
It's nearly there.
Yeah.
But the other two bits that you briefed on yesterday, they won't be coming forward.
Yeah.
So it's a minor bit.
And obviously there's probably quite a lot of work in in the background as well, probably in preparation for legislation coming forward for the third and fourth quarter of this year. And I just wanted to know, Minister, whether any pieces of legislation are quite significant in nature.
Sorry. No, because that's already lodged.
I know it is.
Yeah. So there's the the orders won't be lodged, so it's not going to be state's business. So when you're thinking about, if I'm totally honest with you, I've been focusing on what I could get done between now and the election.
Okay.
There are some big bits of legislation. There'll be secondary legislation for the consumer credit, which will be later this year. Yeah, the repeal of the control of borrowing.
Of the repeal, okay.
Yeah, so there's an order that's going to make some changes, but it will be repealed and replaced with a new bit of legislation.
Yeah.
I would hope that that will be done by the end of the year. So there's plenty of ongoing work.
Yes, no, it sounds like it. Yeah, okay, no, thank
Thank you.
Chair. Thank you.
Minister, we're probably going to get through all of our question areas, which is a first. So
I've been short.
it's probably a slightly lighter, but I think still important question area for our last section. And it's to do with the Young Franco-British Leaders Programme.
Yeah.
Can you give us some insight into what the ambitions are for that programme, explain what the benefits are, and also what's coming up in terms of that programme in the next year?
Well, at its heart, it's a people-to-people exchange. It's building relationships with young leaders who are going to be influential in their communities, so that they can continue those relationships later in life, and it delivers understanding. So I think the first two Jersey leaders found it extremely beneficial. They were able to, at the summit, meet President Macron, Prime Minister Starmer. We are just in the process of advertising for two new leaders for the next cohort. It's also meant that we've had other engagement in Paris with the the French chairs of the programme, as well as the UK ones as well. Deputy Morel recently participated in a panel event on power and trade at the French National Assembly, which was organised by Franco-British Young Leaders Programme as well. So it's not only working really well for those leaders who are on the programme, it's also building more relationships between governments as well.
Was that power as in political power or energy, do you know?
Energy.
Energy, right. That's an interesting area. Okay, thank you for that. So one question I've got more generally, I suppose, this is potentially an opportunity to have a little bit of fun in our last quarterly hearing. So you'll be aware of...
already.
Yeah, well, our definition of fun might differ. You'll be aware that the Year of the Normans is coming up.
There's no doubt.
Yeah, I'm sure there's an intersection somewhere on the Venn diagram. You'll be aware that the Year of the Normans is coming up. I think it starts this year and it goes on maybe beyond. Whose area is that specific?
Yeah, well, it is. It's 2027.
Yeah.
At our, well, do you want to cover it or do you want to cover it? Because the person that leads it, Alex, who leads our European engagement, isn't with us today.
I mean, this is clearly an international thing. It's a bit of soft power for the Normandy region, of course, but it's something that potentially would have fringe benefits for lots of other partners. Is it something Jersey's going to be actively engaged in, and how?
Yeah. So we've got so the French office Beyond is leading on us for this. I mean, discussions are already ongoing, so they're taking part in meetings with the Normandy region. Guernsey obviously involved as well. Paris is also very interested too. It's really, in terms of government responsibility, it's split between external relations and economy, because obviously you've got the heavy cultural element as well there. But yeah, discussions are ongoing in terms of the programme. We've got funding in place to support it, so we're really excited about how it all develops for 2027 and ministerial and political involvement in that.
Okay.
So we see it as events in Jersey,
Yeah, it will be.
and also coordinating and participating in events in Normandy
as well.
and France, but also in the UK, because as you know,
What kind of events are we talking about? Will it be across government, in different departments? Is it cultural or is it financial as well?
Primarily it'll be cultural.
Yeah.
Primarily it'll be cultural. But I don't have the detail of the programme
No, that's fine.
in front of me. But I mean, I can obviously.
we can provide.
It's
where,
in
later
development at the
thinking,
moment, and I know you've been involved in some of it, Deputy, as well. So I can certainly give you some more detail after this.
Minister, just to throw you a googly, is that whilst it might be...
Am I a Norman? Is that what you're going to ask me now?
Well, we don't need to do any DNA tests here, but
Probably.
I think it's probably quite uncontroversial to celebrate a year of the Normans, but if it comes to celebrating the year of William the Conqueror's birth, to what extent do you think that's problematic, that we should be celebrating somebody with a questionable track record, albeit in his time, but as a tyrant? Do you think does that ever come up for discussion?
Well, it is a googly because
Presuming everyone's switched off by this point, so I think it's quite safe to answer.
because which of us actually knows? We don't, do we? We've got all of these labels that have been thrown at him over the years. There is another school of thought that says that's all nonsense and was just a part of its time. I don't have any problem with. I mean, there's even doubt, of course, in some historians' mind that this 2027 is the right year. There's so much uncertainty. So we remind ourselves that the lives of our predecessors 1,000 years ago were quite different from our lives today, and the way that you record things, the way you think about numbers and all of that was totally different. And the lives that everybody lived, it was not unusual for lords of particular regions to be at war with the other region, and therein lay the
It's often the civilians that pay the price, I think.
I think it could be argued, Chair, that that's always the case.
Yeah. So, Minister, just to finish on a final positive note, do you see the work of the Franco-British Young Leaders Programme, the regional work that's going on with Normandy, are we getting into a position where actually we're getting stronger relationships again? We're rebuilding in some cases or strengthening pre-existing relationships, both with the regions but also with Paris, Brussels, etc.
I think we absolutely are. There's more engagement now than there has been since from before Brexit. That's certainly the case. But we shouldn't confuse that with us getting them what we might want from a commercial point of view, because as we know, our friends and colleagues in France are fiercely independent and competitive themselves.
Thank you. Okay. If everyone's happy, any further questions?
No, not from me.
Anything from your side, Minister?
No, thank you.
Thank you for attending.
Thank you.